In this part, we shall have a discussion about contingent contracts and some other special types of contracts. We shall discuss what are contingent contracts, what are essentials of a contingent contract, some legal rules regarding enforcement of contingent contracts, what is difference between contingent contract and wagering contract, and then we will discuss something about quasi contracts, what is their meaning, and then what are the types of quasi contracts. So first of all, let's understand the concept of contingent contracts. A contract may be an absolute contract or a contingent contract. An absolute contract is one in which the promisor binds himself to the performance of the contract in any event. As against this, a contingent contract is a contract to do or not to do something if some event collateral to such contract happens or does not happen. Section 31 gives us this definition of contingent contract. Say for example, MNO Limited contracts to pay rupees 50 lakhs if R's house gets destroyed by earthquake. Now this is a contingent contract where promise of MNO Limited depends upon happening of an event, that is destruction of R's house by earthquake. Another example may be Mr. Pratham agrees to sell his house to Tanu if he wins the court case related with the house. Here again, promise of Mr. Pratham is dependent upon him winning the court case. This is again a contingent contract. Some typical types of contingent contracts are contracts of insurance and contracts of indemnity. In both of these contracts, the performance of a promise gets dependent upon happening or non-happening of an event, and that's why these contracts are contingent contracts. Now let's see what are the essentials of a contingent contract as per law. There are three essential elements of a contingent contract. The first is this, that the performance of a contingent contract depends upon happening or non-happening of some event. This event must be uncertain. If it is a certain event, then the contract is not a contingent contract. And finally, this event must be collateral to the contract. In next slides, we will be discussing each of these three essential elements in some details. The first essential element of a contingent contract is that performance of a contingent contract is dependent upon happening or non-happening of some event. Say for example, Nishank promises to pay rupees 10 lakhs to the bank if his friend Shashank fails to repay the loan. Mr. Nishank shall be required to perform only when event of failure by Shashank happens. If there is no failure by Mr. Shashank, then the promisor Nishank shall not be required to do anything in this contract. This is a contingent contract. The second essential element of a contingent contract is that the event on which the contingent contract is dependent, this must be an uncertain event. If the event is certain and the contract is bound to be performed in any case, then this will not be treated as a contingent contract. For example, Mr. J promises the contractor who is constructing his house to pay rupees 50,000 if the construction is completed before June. Here, the event is completion of construction before June, which may or may not happen. It is an uncertain event, and that's why this is a contingent contract. So the second element is this, that the event must be uncertain on which the contract is dependent. The third essential element of a contingent contract is that the event on which contingent contract is dependent should not be a part of the contract, but it should only be a collateral event. It should only incidental to the contract. This event should neither be performance promised or it should not be a consideration for the promise. Say for example, when somebody hires a car for trip to a place and promises to pay after completion of journey, this is not a contingent contract. This may be called a conditional contract, but it is not a contingent contract. Here, the event on which the contract is dependent is not collateral. It is not incidental to the contract. It is part of the contract itself. To understand the concept of contingent contract in a better manner, we need to differentiate the contingent event with the will of the promisor. Now, the performance of a contingent contract is dependent upon happening or non-happening of an uncertain event. This event may be an act, and accordingly, contract may be contingent on the act of the party or promise of a third party. However, this contingent event cannot be only a will of the party to the contract. Let's understand this differentiation with the help of an example. If Mr. Rajesh promises to pay Mr. Manoj rupees 1 lakh if Mr. Rajesh desires. Now, this is not a contingent contract. It is dependent only on the will of Mr. Rajesh. In fact, it is not a contract at all. However, Mr. Rajesh promises to pay Mr. Manoj rupees 1 lakh if Mr. Manoj goes to Delhi before next January. Now, this is a contingent contract since it is dependent upon the act of Manoj going to Delhi before next January, and this is an uncertain event. So what is required to be seen for the contingent contract? That it should be dependent upon a contingent event which may or may not happen, but it should not be dependent only on the will of the party to the contract. After discussing the meaning of the contingent contract and its essential elements, now let's discuss what are the legal rules regarding enforcement of a contingent contract. Section 32 to 36 of the Contract Act gives us 5 different rules regarding contingent contracts. Section 32 talks about a situation when the contingent event, the contingency, is the happening of an event. Whereas Section 33 talks about a situation where contingency is non-happening of an event. Then Section 34, which talks about the situation when a contingency is the future conduct of a living person. Section 35 discusses the situation when a contingency is the happening or non-happening of an event within a fixed time period. And finally, there is section 36, which analyzes the situation when the contingency is an impossible event. So these are 5 different rules regarding contingent contracts, which we shall be discussing in detail in next slides. Section 32 of the Act discusses the situation when contingency is happening of an event. Section says, in this case, the contract cannot be enforced unless and until the event has happened. Here, the contract is dependent upon happening of an event, and law says this contract cannot be enforced unless that event has actually happened, and if the event becomes impossible, such contracts become void. Say for example, Mr. Raj makes a contract with Mr. Hari to buy his house if Shyam dies before Raj. This contract cannot be enforced till the death of Mr. Shyam. Here the contract is dependent upon happening of an event, that is the death of Mr. Shyam, and this cannot be enforced unless and until that event happens. Another example, Mr. A contracts with Mr. B to sell a horse at a specified price if C refuses to buy the horse. C has already been offered the horse, and A says only after his refusal he will be selling the horse to B. In this case, the contract cannot be enforced by law unless and until C gives his refusal to buy the horse. Let's take one more example. Mr. A contracts to pay Mr. B a sum of money when B marries C. In this case, the contract is contingent upon B marrying C. Now C dies without being married to B. The event has become impossible, and now the contract has become void. Section 33 discusses a situation where contingency is non-happening of an event. In this case, the law says the contract which is dependent upon non-happening of an event can be enforced only when happening of that event has become impossible. If there is any possibility of happening of that event, then this type of contract cannot be enforced in that situation. Say for example, Mr. A agrees to pay Mr. B a sum of money if a certain ship does not return. The ship is sunk. This contract can be enforced only when the ship sinks. Here the contract is dependent on non-happening of an event, that is not returning back of the ship, and this contract can be enforced only when it has become impossible that ship will ever return back. Then section 34 talks about when contingency is future conduct of a living person. And in this case, section prescribes that this type of contract, which is dependent upon future conduct of a living person, this contract shall become void when such person does anything to make that event impossible. Here, the contract is dependent upon future conduct of a living person, and that person has done something which has made happening of that event impossible. The contract shall become void. Say for example, A agrees to pay Mr. B a sum of money if B marries C. Now C marries D. Now the marriage of B and C must be considered as impossible, and then the contract shall become void. However, there is a remote possibility that D may die and then C may subsequently marry B, but right now the event has become impossible, and that's why this contract shall be treated as a void contract. Moving on to section 35, this analyzes the situation when the contingency is happening of an event within a specified time. And here the rule is this type of contract shall become void if at the expiration of this fixed time this event has not happened, or even before the expiry of time such event becomes impossible. So a contract which is contingent upon happening of an event within a specified time period may become void in two scenarios. A. The period has expired and event has not happened. B. Before expiry of that time period, the event has become impossible. In both of these situations, the contract shall become void. Say for example, Mr. A promises to pay Mr. B a sum of money if a certain ship returns within a particular year. This is a contract which is dependent upon returning of that ship within a particular period, that is 1 year. Now this contract may be enforced only if the ship returns within the year. This contract shall become void if the ship is buried before the completion of the year, or the year has completed and ship has not returned back. The next rule regarding contingent contract is in a situation where contingency is non-happening of an event within a specified time period. In earlier slide, we have discussed the situation where contingency was happening of an event within a fixed time, and now we are discussing contingency which is in the nature of non-happening of an event within a specified time period. Here, the rule is this type of contract may be enforced only when the time fixed has expired and such event has not happened. Or it may be enforced when before the time fixed has expired, the event has become impossible. So any contract which is contingent upon non-happening of an event within a specified time period may be enforced in either of two situations. A. When the time period has expired and event has not happened, and B. When even before expiry of that time period, it has become certain that event shall not happen. Say for example, again talking about the same situation which we have discussed in last slide, Mr. A promises to pay Mr. B a sum of money if a certain ship does not return within a year. This contract may be enforced if the year has expired and ship has not returned, or the ship is burnt within the year itself. And then the last rule related with the contingent contract has been given by section 36, which is related with a situation when contingency is an impossible event. And here law simply says this contract is void. So any contract which is contingent upon happening of an impossible event, this contract is void as per section 36. The law further says this type of contract is void even if the fact of its impossibility, the fact of impossibility of the event was not known to the party at the time when agreement has been made. Still the contract shall be treated as void. Say for example, A agrees to pay B some amount if a triangle can be made with only two straight lines. Now this is impossible, and as such the agreement is void. Another example may be where A agrees to pay Mr. B rupees 1000 if B will marry A's daughter C. At the time of agreement, C is already dead, though none of the parties were aware about this fact. This agreement is also void because it is contingent upon happening of an impossible event. And now let's see how a contingent contract is different from a wagering contract, a contract of wager and a contingent contract. What are the differences? The very first difference is this, that a wagering contract, it is a promise to pay money or money's worth with reference to an uncertain event happening or not happening. So it is a promise to pay money or money's worth. A contingent contract is a contract to do or not to do something with reference to a collateral event happening or not happening. Then a wagering contract consists of reciprocal promises. Both the parties promises to pay each other. One promises to pay on happening of something, another promises to pay on not happening of same thing. However, a contingent contract may not contain reciprocal promises. Then, in case of wagering contract, the uncertain event is the core factor. In contingent contract, this event is collateral. Wagering contract is also essentially contingent in nature, but a contingent contract may not be wagering in nature. In case of wagering contract, the contracting parties have no interest in the subject matter. The subject matter is something alien to the contract. In a contingent contract, the contracting parties may have interest in the subject matter also. In wager, it is actually a game. Losing and gaining alone is what matters. This is not the situation in case of a contingent contract. And a wagering agreement is void, a contingent contract is valid. After analyzing contingent contract, let's try to understand another type of contracts which are called quasi contracts. A quasi contract is a very interesting concept of law. This is in fact an obligation that the law creates in the absence of an agreement between the parties. There is no agreement between the parties, but still the law is creating an obligation. There are certain situations where a person may receive a benefit for which the law considers that he should make some payment to another person even if there is no contract between the parties. These situations are known as quasi contracts. These contracts create same obligation as in the case of a regular contract. So we may call a quasi contract as a contract created by law in absence of an agreement between the parties. The law considers 5 such situations which are considered as quasi contract where the law creates a contract between the parties. 5 different sections which we will be analyzing in detail in subsequent slides. The first such case where the law creates an obligation on the party in absence of a contract is given by section 68 of the Act. This section talks about a person who is incapable of entering into a contract, and the law says this person or anybody else whom this incapable person is legally bound to support. If any of these is supplied by another person, something which is necessary for the life of these persons, whether that supplier shall have any remedy against these persons, law says that the supplier shall be entitled to be reimbursed from the property of such incapable person. Say for example, Mr. A supplies to Mr. B. Mr. B is a minor and Mr. A supplies to him some books necessary for his study. Mr. A is entitled to be reimbursed from B's property. B, being a minor, cannot legally enter into a contract with Mr. A, but still here law shall create a contract between Mr. A and Mr. B, and Mr. A shall be entitled to be reimbursed from the property of Mr. B. Let's take another example. Mr. A supplies daily ration to the wife and children of Mr. B, and Mr. B is a lunatic. Here again, Mr. A is entitled to be reimbursed from Mr. B's property. The next situation is contemplated by section 69, which talks about right to recover the money paid by a person for another. Section says that where a person who is interested in the payment of money, which money is actually somebody else is bound by law to pay, and this first person, because of his interest, makes the payment. There is person A who is bound to pay the money, but there is person B who is interested in this particular payment, and now Mr. B makes the payment. The law says this person who is making the payment is entitled to be reimbursed by other person who is legally bound to make that particular payment. A very simple example may be Mr. A is tenant of house owned by Mr. B. B has not paid municipal taxes due to municipal corporation, and that's why corporation has ordered seizure of that property. Now Mr. A, being a tenant, is interested in the fact that Mr. B pays the municipal taxes. Now Mr. A pays the taxes to the corporation. He can recover this money from Mr. B. The third type of quasi-contract is created by section 70 of the Act, which says that where a person has lawfully done anything for other person, or he has delivered anything to other person, and this first person was not intending to do so graciously free of cost, and the other person has enjoyed the benefit of these things delivered or something which has been done for him, this other person is bound to compensate the former in respect of things so done or delivered, even if there is no contract between two parties. One party has enjoyed the benefit of a non-gracious act done by that other person. This party is required to make the payment to other person. Say for example, Mr. A leaves certain goods at B's house by mistake. B treats these goods as his own. Now he is bound to pay A for these goods. On the other hand, if Mr. A saves Mr. B's property from fire, A is not entitled to compensation from B if the circumstances show that he intended to act graciously. And then section 71 talks about responsibility of finder of goods and simply says that a person who finds goods belonging to another and he takes them into his custody, this person is subject to the same responsibility as a bailee, meaning thereby law creates a contract of bailment between the person who has found the goods and the person to whom goods actually belong. In later part of our discussion, we will discuss about contract of bailment in great detail, and there we shall see what are actually duties of a bailee. Right now, we can see that the finder of a goods has to take proper care of goods as a man of ordinary prudence would take, and he will not have any right to appropriate the goods, and then he must return the goods if the owner is found. These are the duties of a bailee, which we shall be discussing in great detail in next part of our discussion. Right now, let's have an example. Mr. Shailendra, a shopkeeper, finds a diamond bracelet in his shop and keep it an open shelf from where it goes missing. The law says Shailendra is liable to compensate the owner since he has not taken the proper care which a prudent man would have taken. Because Mr. Shailendra was having the same responsibility as a bailee in this case and he has not taken the proper care of the goods, he shall be liable to compensate the owner. Last in the series of quasi-contracts are the provisions given by Section 72, which talks about liability for money paid or things delivered by mistake or by coercion. Section says that a person to whom money has been paid or anything has been delivered by mistake or under coercion must repay it or return that particular thing. Let's take two examples. First case, Mr. A and Mr. B jointly owe rupees 100 to C. A alone pays the amount to C. B, who is not aware of this fact, again pays rupees 100 to Mr. C. Now Mr. C is bound to repay the amount back to Mr. B. This amount has been paid to him by mistake, and as per Section 72, C must repay this amount back to Mr. B. In another example, an airline refuses a passenger permission to board a flight unless he pays extra baggage charges, though the baggages are within the permissible limit. The passenger pays the sum demanded in order to board the flight. This money has been demanded from him under a threat that he will not be allowed to board the flight, and that's why he had to make that payment. Now he is entitled to recover so much of the charge as was excessive. So this was our all discussion about contingent contracts and quasi contracts. Now just to quickly summarize the whole discussion, a contract may be either an absolute contract or it may be a contingent contract. A contingent contract is one where the promisor undertakes to perform the contract which is dependent on happening or non-happening of a specified future uncertain event, which event is collateral to the contract. Then, all wagering agreements are basically contingent agreements, but all contingent contracts are not wagering agreements. Quasi-contracts or constructive contracts are those contracts which are presumed by law. These are the contracts which are imposed by law. These are the obligations which are created by law. A quasi-contract may be of following 5 types. They may get created under following 5 conditions, 5 situations. necessaries of life supplied to incapable person or to his dependents. A person pays money on behalf of one who is legally bound to pay. Person enjoying the benefit of non-gracious act. Person who finds the goods belonging to others, and person to whom money has been paid or anything delivered by mistake or under coercion. In all these five situations, in absence of an agreement between parties, law shall create an agreement and which will have same effects as a normal contract is having. Thank you.